This thing works.
Yes, push this one to
Okay,
advance.
very good. Well, thank you. Nice to be here. My topic is a bit different, and it will have a law focus, but it is an interdisciplinary approach. Therapeutic jurisprudence really is can be considered a healing approach to the law in general. Our focus today, and my main interest, is in its application to criminal law and juvenile law. What I'm going to speak with you about now is, excuse me, an international and interdisciplinary program or project that is to try and mainstream therapeutic jurisprudence, meaning to see the extent to which it might be able to apply outside of the context in which it is now best known. The context in which it is now best known is in these special problem-solving or solution-focused courts like drug treatment court, mental health court, domestic violence court, and the like. These are courts that were really designed specifically to allow for a lot of what we do in therapeutic jurisprudence, or what we support in therapeutic jurisprudence, to come into those courts and to work in those courts. I will try and explain that in a moment. This project is one that is was launched formally through the Hague Institute on Innovating Justice, and part of their platform on innovating justice, and that's where these slides come from. The gist of therapeutic jurisprudence, or the insight of it, really would be that whether we like it or not, whether we know it or not, the law has an effect, often has an effect, a therapeutic or an anti-therapeutic effect. And traditionally in the law and in law schools, surely this has been ignored, the impact of law on emotional well-being. We really urge that it be taken into account, that it be studied, and then ultimately it be factored into our efforts at law reform and at the administration of the law, instead of being simply ignored. It's not to say that therapeutic goals should trump other goals or should be the only goal, but it is that we should be aware of the therapeutic and anti-therapeutic aspect of our legal actions and of our system. The best website that I'd like you to take away from this is therapeuticjurisprudence.org. The best thing isn't on the slide, but next time it will be. That will give you resources and places to go if you're interested in follow up on this. And my email, davidbwexler@yahoo.com. Very anti-therapeutic to omit the B. So, but if you put in the B and write to davidbwexler@yahoo.com, I'm a good emailer, trust me. I'm way better at email than at PowerPoint. So this project is really designed through The Hague to have a small group of us, myself, Magistrate Pauline Spencer from Victoria in Australia, from Melbourne, and Mike Jones, who's a former judge in Arizona and now on the Arizona Summit law faculty. We're the ones who really proposed the project in the Hague as small teams of experts who will try and work with interested communities to try and see the extent to which therapeutic jurisprudence might be brought into their legal system. It is, as I said, a very interdisciplinary subject matter that involves lots of psychology, criminology, and social work. I'll talk about that at the very end. And it works with offenders in the criminal law area, with offenders and also with victims. Victims is really, our attention has turned more recently to victims, I should put it that way. It started out mainly with offenders, but there has been very good work now bringing victims in as well. And we have also a Facebook page that is a good resource. Well, as I said, therapeutic jurisprudence has mainly been applied in drug treatment courts and mental health courts, and these are structured so as to invite a number of TJ kind of practices. These are good courts, and these are good alternatives to the traditional criminal. They are part of the criminal justice system, but they're good alternatives to the traditional criminal justice system, and we're very supportive of them. However, what's happening is that though there's been a movement to try and extend the scope of problem-solving courts, that isn't happening all that much. Partly there are major budget problems that are leading to their constriction, even to their elimination. In Queensland, Australia, some very successful courts have actually been eliminated for budgetary reasons. So that has led people to say, well, besides that it's a shame, what else can we do? If we can't operate, can we take these skills and this knowledge and apply them elsewhere in the criminal justice system where these people will inevitably go if these problem-solving courts no longer exist? Let's assume, however, that they exist, that they thrive. There are, as you likely know, serious political and ideological constraints on the front-end admission to these courts in the form of eligibility standards. They're unlikely to be too broad, in other words, to be broadened substantially to let all sorts of people into these alternative methods. And therefore, a lot of these people are going to end up in the ordinary criminal justice system. We've seen here that the jails and prisons are really full of people with drug problems, with alcohol problems, with mental health problems. Michael Perlin, who some of you probably know, who's a leading mental health law academic and advocate, has recently attributed a substantial part of the criminalization of mental illness to some anti-therapeutic Supreme Court decisions. And not the ones that simply bring civil rights that Madeline was speaking about earlier, but rather going back to the 80s in the wake of the Hinckley case and the aftermath of that and how it changed our culture about an awful lot of matters of mentally ill in the criminal justice system. The U.S. Supreme Court came down with a case called Jones in, I think, 1983, which upheld for someone who was successful in urging the insanity defense, not guilty by reason of insanity. That person was found not guilty by reason of insanity, was committed to a mental hospital, St. Elizabeth's, in fact. It was a local case, and I think the crime was like attempted shoplifting of a coat or a jacket in a department store here. And he pled not guilty by reason of insanity and won, but ultimately his lawyers were bringing his case to the U.S. Supreme Court saying, wait a second, he's been confined forever based on this successful plea. And the Supreme Court, again, I think probably in the wake of the atmosphere of Hinckley, said, well, that's okay. Once you're in the system as mentally ill and dangerous, until you're no longer both mentally ill and dangerous, you can be confined. You're not guilty. That's not a criminal conviction. That is limited. And so that rule, obviously, we would look at it as an anti-therapeutic rule in the sense that it discourages people from asserting this defense. People in Jones's situation now don't raise that defense because they're better off in the criminal justice system, for example. And so we are looking to see the extent to which we can bring therapeutic jurisprudence insights into all sorts of stages listed here. Early diversion, of course, bail hearings, plea negotiations and judicial settlement conferences, the imposition of sentence. Many of those sentences can be a community-type sentence, a non-incarcerative sentence, for example, and in post-incarceration procedures and conditional release, parole or its equivalent. Dr. Greenberg spoke of the police. Part of our project does indeed involve police and police interrogation and the newer methods of investigative interviewing, which has been studied. I think it was started by a psychologist named Ronald Fisher some time ago. A lot of work has been going on in Sweden by Ulf Holmberg, who's a police officer turned psychologist and psychology professor, on this type of more humanistic interviewing techniques, both of suspects and of victims. And the research showing that this type of interview, as opposed to the more abrupt, just the facts, ma'am, that may exist in the traditional interrogation method, it produces, according to their research, more important information, and it leads to greater well-being on behalf of perceptions of subjective well-being on behalf of the suspects and of victims. So we're looking at all of these kinds of stages, and when we look at the law, and this is important, we're concerned with the law in action, not just the written law. And when we're looking at the law in action, we're looking at the rules of law, at legal procedures, as well as the roles of legal actors, that is, the behavior of judges, of lawyers, and of therapists and others, police officers, working within the legal context. We use this metaphor looking at the rules and the procedures, the actual applicable law, the legal structure or legal landscape, as bottles. And we look at the practices and techniques of legal actors, the roles played by those legal actors as wine. And really what we're trying to do then in this project in the general criminal system is looking at the different bottles across there and seeing to what extent the TJ practices and wine can be poured into those bottles. The practices such as in court, just active listening and giving someone participation and voice and making them feel that they have some voluntary say over what happens to them. All of these kinds of things, we have lots of the wine worked out, and the wine has been used pretty well in the problem-solving courts. Now, if we're looking beyond the problem-solving courts, we look at these other stages of the process. As I said, police interviewing, diversion, criminal settlement conferences, bail, imposition of sentence, conditional release, all of those sorts of stages to see, will they allow these kinds of practices in there? Or, and if so, are they being used that way? Or, because of lack of interest or knowledge or whatever, are they not being used to the extent to which they could be and could be profitably used? And what kind of training would be required of what kind of people to get the law as it is now to work better? And that's an important aspect. Very often we think of law reform as just change the law, but we're very interested in the wine as well. Can we work with the existing law and improve it? In the case of police interrogation, for example, there's probably not much law really restricting us from doing it the investigative interviewing way as opposed to the traditional way in the law itself. If you comply with Miranda and do all that, you can then go on with the way in which you would like to behave. So we're looking at bottles that we call either TJ friendly or not friendly. The TJ friendly ones are ones not necessarily that are working well, but that could work well, that have the potential to be filled with the TJ kind of fluid. The ones that aren't capable of having the TJ fluid come in, we think of as unfriendly, and those are the ones where we would think of law reform. So an example of pouring better wine into an existing bottle can be seen in a very simple situation of the imposition of probation. Instead of the judge unilaterally ordering probation and its conditions, which is kind of the traditional way, I've thought about this, I'm putting you on probation, here are the conditions of your probation, and that's the end of the imposition of sentence. the judge could begin the process by soliciting the offender's input, asking the offender to personally justify a probationary sentence and the conditions that the offender deems necessary and appropriate, curfew, AA meetings, school attendance, etc. And so this red light is very intimidating. How much more do I have? Okay. Very anti-therapeutic. Let's see. Okay. When one imposes a sentence, a probationary sentence, there are lots of different ways that one can do it. So this is a TJ-friendly structure in the sense that it has a lot of room for discretion in behavior. And according to the procedural justice literature, the latter way should increase offender compliance and increase a sense of fair treatment. And this is how we learn the TJ wine from our vineyards of psychology, criminology, social work. This has also been used, incidentally, in a paper I wrote a long time ago, in the conditional release of insanity acquittees. If people, despite the Jones case, plead insanity and win and are hospitalized and can be released, usually preceded by conditional release by a court order, judges and the way in which they can conduct those hearings presumably can do an awful lot to increase the sense of fair treatment, to increase offender compliance, and so forth. So the kind of the interdisciplinary nature of this is really for us to look at matters out of the social sciences that can be relevant to the work of judges, lawyers, and others. Relapse prevention planning has been used, like James McGuire's work, reasoning and rehabilitation approach that originated in Canada, Shad Maruna's excellent work on desistance from crime, Mike and Bauman Turk's work on facilitating treatment adherence. They wrote some time ago about in medicine generally, but a lot of that can be applied to psychiatric situations and to legal situations, behavioral contracting, giving voice, giving clear instructions, and condemning acts rather than actors, John Braithwaite's work on restorative justice, and so on. So this is kind of what we're doing. I'd be most interested in following up if any of you are. I have cards here with that David B. Wexler at yahoo.com. I'd be happy to take your cards, and thank you very much.